Noted. Morning, everyone. One second. Should we do it again? Hold on. All right. Okay, this is chapter 9. It's all about the medical records for your week coming up. So, as far as the medical record goes, these are some of the things that are part of a medical record. Everything that is written in this document, it has to go in that relates to the past history, whatever the current diagnosis and treatment is, any correspondence relating, to the patient, whether it's from the patient or maybe another doctor has seen the patient and has decided to send their feelings in. It is a legal document. It may be subpoenaed, and there's going to be questions that come up. Who owns this record? Can a patient see it at will or request or not? What exactly happens when the medical record is subpoenaed? It's generally not the whole record, which could be tremendously large. If it's on paper, they are only concerned with the things that are related to the specific incident. Okay, moving right along, what is the purpose of the medical record? It's supposed to follow the patient from birth to death. It is a document, obviously, for continual management of the patient's health care, tracks their health, provides data and statistics, provides medication amounts that are prescribed. It tells whether or not there's any allergies. It should follow everything. And then there'll be questions that come up like, how long should medical records be kept when the patient has either passed away or moved on to another state or another doctor? We will come to that. So the contents of a medical record are listed here, and it's pretty clear. You can see anything that's personal information about the patient or clinical data, prescriptions, consent forms, any referrals, if that's ever happened, for occupational therapy or physical therapy or MRIs or whatever, records of medical examinations and x-rays. What doesn't belong in here are personal opinions. And you saw, if you've read the chapter, the patient is annoying. Now, the patient may be annoying, but it's not something that goes in the medical record. That could be other things, one more thing, physicians and healthcare professional notes. And that's just it, professional notes. Nothing about, your personal opinion about the patient. There are two common forms of charting, which is the POMR, the problem-oriented medical record, includes what happens at each visit, which is, you probably have seen the acronym, SOAP, the subjective, objective assessment and plan. Subjective is, what does the patient say or something? I have a headache. I have been itching. I have had fever that's gone up and down over the past 3 days. I have a bad bellyache. That's subjective. You can't see it, but objective is, can you measure it? Yes. Things like lab reports, vital signs. Someone says, I have a headache. You can't see the headache for sure. If they say, I have a fever, that's subjective. But if you then take their temperature and it shows that there's either a fever or not,
That is objective. Subjective can't be seen but is felt. Objective is measurable. Assessment is what the doctor decides is probably wrong with the patient, and then the last is P, the plan for treatment. So every physician basically will go through this in medical school 101 or first class. That's the way of starting a medical record. So what happens if you make a mistake? Corrections and alterations. We've kind of gone through this before, but there is, the papers these days are very sensitive. They can be, there's all kinds of procedures, things can be put on paper to see if something has been whited out or erased or something else has been written in. The best way is to just be honest, because nobody is infallible here. If you've made a mistake, you draw a line, one line, no squiggles, no big black, things. You draw the line through the error, write the correction above the error, you date and initial it. Do not use whiteout. Do not erase. Make sure you use blue or black ink only, not pencil and not colored ink, because they cannot be either faxed or copied. Falsification of any medical record is an open door for any kind of criminal indictment. There's a couple of questions in your chapter this week that like the what if situation, and one of the situations was, what if you saw a nurse making a change on a medical record just before she had to send it to the lawyers? There was that subpoena ducis tecum, which means you have been subpoenaed to court, or part of this record has been subpoenaed to court. It's got to go. It absolutely has to go. For this, you don't need the person's permission. The court is higher than any permission, so it has to go. If you've noticed somebody making corrections, that would be the time to speak up, and they can go to jail for that. Now, timeliness of documentation. If you have seen a patient, you should be charting it, whether it's paper or electronic. It should be charted as soon as possible, not let you go home and you decide, I bet you chart that, I'll go back the next day and put it in. As soon as the care occurs, or as soon as humanly possible afterward, it needs to be taken care of. The physician has to chart within 30 days following a patient's discharge from a hospital. Doubt that it generally takes that long, but in an office situation, pretty much you get some time at the end of the day, or maybe even several times a day, where you're not scheduled to do anything but update your charting. Completeness of entries, super important. Super important. How many times you are going to hear this statement, I don't know, but I'll go on record as saying it too. If it wasn't documented, it wasn't done. Now, you and your physician and anyone else can swear on a stack of Bibles, but if it was not written down or keyed in, it's not accepted by the law. Confidentiality, we definitely have gone through this a lot this quarter. Any record cannot be released to a third party without patient's written consent. Only specific records should be copied and sent if they are subpoenaed to court, and taking photos or other visual images of the patient without their consent is invasion of privacy. So who owns the record? basically the physician owns, or the hospital, whatever, owns the medical record, but the patients have the privileged communication statute in their favor, and they have access to their records at any time. They can be given a copy of their medical record. They may not be given the original. The original must be kept. And continuing on, if the patient decides to let someone else have access to their record, they sign a release in writing, and there is the doctrine of professional discretion, which kind of lays in the background. If the patient has a medical or some sort of an emotional problem, the physician may determine that it is not in their best interest to view their medical record. It may upset them a great deal. So this is when that doctrine of professional discretion would actually step in. So receipts of information, as I had said before, you never send the entire medical chart unless it's requested, like less is better. You don't send the original. If something is requested about a patient that's 68 years old, you don't have to go back to when they're 12 and send all of that stuff. You just send what is requested for the particular lawsuit that is being instituted, and you copy that. You never send the original. This is the one time when it's requested by the court that you do not have to have the patient released. The record can't be released normally to the patient without the physician's permission, because they may want to have that doctrine in place. The patient must sign a release form for information to be sent to an insurance company. Everything has to be kept pretty darn private. Due to the Privacy Act of 1974, an agency can maintain information only if it's relevant to its authorized purpose. Any person, any citizen has the right to gain access to their records if necessary, and it applies to federal agencies and government contractors. The open record laws in states, some have the Freedom of Information law that grants public access to records maintained by state agencies. Interesting. Medical records are generally exempt from this statute. So that means if you want to go find out how much your governor is making and how much he paid in his income tax, first income tax in the last 10 years, that you can find out. But can you find out if he's had the flu or any STDs? Absolutely not. The alcohol and drug abuse patient records are sacrosanct. Absolutely nobody has access or should have access to them. The Public Health Services Act protects any patient who is receiving treatment for drug and alcohol abuse, and information may not be given out. And if it is, the person who does give it out is subject to being slapped with a lawsuit and potentially imprisoned. A person or program that releases that type of confidential information can get a severe criminal fine. I mean, this is something that can destroy someone's life, obviously. The only exception would occur if that patient requires emergency care to save their life. So another question I brought up earlier, like how long do you have to keep some of these records? They can get voluminous, they can get very. Every state decides their own, format for how long they're going to keep their records. It's generally 10 years from the date of the last entry, and with a minor, it's kept until they reach their majority, which is 21, plus the statute of limitations on all cases is generally 2 years. So in a minor's record, they are stopping being seen. They have to reach 21 plus 2 more would be 23 years of minor's record must be kept from the beginning. A lot of people don't have the space to store these heavy medical records that are, paper-based. They usually kept in the physician's office as long as they're being seen, and then if they haven't been seen for usually 2 years, the physician may have it converted to microfilm, and then it's kept in a storage space or in a a locked area with a fireproof type of a file cabinet. Electronic medical records can be created, modified, authenticated, etc., stored and retrieved by computer. There always should be some safety measures taken as to how many people and how they're going to get access to these records. Not every person should be allowed to do it. It should be on a need-to-know basis. There should be a verification code, maybe a fingerprint, whatever it is that's decided. It's important that not everyone has access. We've been seeing in some of the cases we've had for assignments this quarter that the Privacy Act can be easily not followed. So, moving on down to reporting and disclosure requirements, certain states, or most states, laws do require disclosure of some confidential medical record information without the patient's consent. Reporting and disclosure are duties of the physician. For example, any communicable disease, and that includes the STDs, must be reported by law to the State Department of Health. It is kept confidential by the office, the medical office, and by the State Department of Health in that they don't tell anyone else. But they do have to contact the person who is affected and decide whether or not they are receiving the correct treatment and who else they may have infected. And lastly, the use of the medical record in court. This is that term that I mentioned, subpoena ducis tecum. It is a written order requiring a person to appear in court and give their testimony, and they have to bring the information that has been required by the court in this case, whatever is described in the subpoena, and nothing more, and nothing less. If they were to disclose any information improperly, any healthcare institution, a provider, can face civil liability, which can cost them an awful lot of money for releasing any type of medical records without proper patient authorization. So, I think that covers it for Chapter 9, and I hope that this has helped you. I look forward to some feedback if you have a moment, and we will talk again soon.